One time. One time. One time. One time. One time. One time.
Pita, kuna batu hiyo side nyingine. Ameshakuja. Ndio amekuja. Akokoti.
Not for their case because we want to strongly oppose an attempt to charge Honorable Jayne. We oppose any attempt to take a plea because we are seeing the charge. For the quorum purposes, Your Honor, my name is Stephen Kalonzo Musyoka. We have with us Honorable Justin Muturi. It's a household name. Councillor CN Kihara. We have Councillor Keragu Kwatuta. We have Councillor Ndego Njiro.
I am present, Your Honor. Good morning.
We have Councillor Waireki Kiarie.
Good morning, Your Honor.
We have Councillor Malemba Daniel.
Present, Your Honor.
We have Councillor Nyamu Boniface.
Present, Your Honor.
We have Councillor.
Sorry for interrupting.
Yes.
Some of your advocates are not properly dressed yet. So you can mention them for purposes of record, but
They will,
not address them.
I think it's the urgency of this matter, Your Honor, but we will comply.
Okay, thank you.
We have Councillor Wambugu Wanjori.
Present.
And we have Councillor Mageto Miller.
Present, Your Honor. Again?
Oh, you seem to have met before.
Yes, I see that.
Indeed. We have Councillor Ngera Alex.
Present, Your Honor.
That is the team on our side, Your Honor.
All right, thank you.
Good morning. For the state, my name is Nora. Together with Mr. J.B. Witty,
Good morning, Your Honor, once again.
Mr. Milimani, and Ms. Sonia. Matter is coming up for free taking, we are there.
Your Honor, we have just seen a copy of the alleged charge sheet. And Honorable Jayne Kihara is supposed to take a plea. The charge of offensive conduct conducive to breach of the peace. Of the Penal Code, Chapter 63, Laws of Kenya. With a casual glance, Your Honor, men and women, members of Parliament like Honorable Jayne Kihara, Your Honor, if it is that they were to be arraigned in court, some have said worse things. Some have even on record as saying they were going to transport goons to make sure that Sabasaba did not happen. And they've never been arraigned. We have, for example, Honorable Kamket, a member for Baringo East, declared openly.
Sorry, it's very unfortunate that I have to rise when Senior Counsel is speaking, but we have an objection to make. Senior Counsel, if you allow.
This is just opening remarks, because we were just trying to point out selective persecution of political leaders. This is nothing. Nothing, Your Honor. Nothing short of political persecution which this country cannot achieve.
We have a concern with
So,
that.
Senior Counsel, I think you made your point. Maybe.
Yes, we were just going to ask, not even in the nature of the opening speech, but it is based on a lot of factual allegations that Senior Counsel, being from the bar, cannot present court without an affidavit. So we would plead that we go straight to the issue without the conundrum of factual matrix, which we are not able to respond to without an affidavit, so that we are on a very disadvantaged position.
Thank you.
Thank you.
Counsel, I hear you. Your Honor, I hear him. I take that objection. But even as I do, others are even on record as saying publicly, public notice. I think court should take judicial notice of that. Even prepared to steal the next elections. And they have not been brought here. We live in the same country, equal rights. We do not have citizen A and citizen B categories. And therefore, I invite my colleagues to argue against this plea taking and to ask Your Honor that the Honorable Jayne Kihara be released unconditionally to go and serve the people of our constituency, Naivasha. We are happy that you found the time because we are afraid, this being a Friday, the intention of our colleagues on this side was to detain her until Monday. But thank you for finding the time. We think that this is not the way to run a country, Your Honor. I thank you.
Mr. Speaker, so you know court sits on Fridays there. So your objection, in as much as you should not worry, we sit on Fridays there.
Thank you. Just once again, my name is Kihara. And if it pleases you, I'll address you very, very quickly on the basis of why we asked you for a fund for the taking of the plea. Both ourselves and our clients have just seen this charge sheet, which is before the court. You have seen the quotation yourself, and the charge is based on section 94(1) of the Penal Code. What is called an offensive conduct that is conducive to a breach of the peace. Your Honor, when you look at the ingredients of the offense of that is charged with 94 Article 1, the particulars provided don't disclose any of the ingredients even on the face of it, assuming we have witnesses and assuming that we'll be able to do what we call legal surgery, where you have to look at somebody's statement, because I think we are operating for a basis that our client is entitled to exercise her right under Article 33 of the Constitution, the freedom of expression. She's an additional member of Parliament whose life and freedom to expression include much more than her personal rights. She has constituents to present and to speak on their behalf freely without any limitation, as to make representation on their behalf at both the National Parliament and any public forum where her duty calls. I've looked, when you look at the ingredients, again, there is nothing insulting on the face of this. There is nothing abusive. And tremendous respect to the office of the Arraigned DPP. This is the kind of offense that used to be charged, that usually is used to charge a drunken man. the drunken man in the market center. So that we are talking, this is the kind of charge. This is not the kind of charge to bring a member of an elected member of Parliament who is serving her third term in Parliament to court. Thank you, and it's completely on the face of it unconstitutional. But my learned friend, Mr. Jiro, will be off further deeper. Thank you.
you, Your Honor. I'll also briefly address you on the legal basis of our application, then I'll invite my learned friends to further defend the arguments.
So, Mr. Jayne,
Yes.
before we proceed, maybe just for order, how many of you, because I can see you are virtually,
Yes, Your Honor.
you process how many of you would be
Thank you, Honor. Authority, I'm sure, would want to make,
after zero?
and so after zero, two others.
I don't think we have any power to decide for them. Maybe the board could just indicate how much time all the three have for order. Instead of telling them how many could speak, we could agree on how. The three is okay, yes.
So let us hear,
No.
let them exhaust whatever they have.
Just stick to the point, Your Honor. I'm sure we are going to do business proposing this case.
I begin to address you by invoking your jurisdiction. And I do so because with the of the Magistrates Court Act. But let me begin by Section 3, which lays down the guiding principle. In exercise of its judicial authority, a magistrate was specified under Article 10 and Article 159, Clause 2, and Article 232 of the Constitution. That's where you draw your jurisdiction from. And then as you exercise this jurisdiction, when adjudicating of a dispute such as this one, what is the court looking at? And Section 4 says the objective of this, it says, Your Honor, that subject to Article 165, it is so square. Borders between a denial, a violation or infringement of a right, a threat to a right, or fundamental freedoms. We address you on the basis that the section under which this charge sheet has been premised, that is Section 94, subsection 1, was enacted in 1930, with the commencement date being the 1st of August 1930. It follows, therefore, Your Honor, that with the enactment of the new Constitution, the ODPP, who has brought us here this morning, ought to have been alive to the provision of Section 7 to the 6th schedule to the Constitution. Section 7 to the 6th schedule, Your Honor, to the Constitution provides that all laws that were in effect before the effective date shall be read with the necessary modification, adaptation, alterations, so as to bring it into conformity with the provision of the Constitution. And while I am not inviting you to look at the constitutionality of that section, I am inviting you to look at whether or not the application of that section falls within the provision of Section 8 of the Magistrates Court Act. I want to make it clear so that my learned friends on the other side may understand that I'm not invoking your jurisdiction to determine the constitutionality. I'm invoking your jurisdiction to determine the applicability of that provision. Therefore, in that sense, Your Honor, Section 94, subsection 1 must be brought within the ambit of Section 7 to the 6th schedule. And the reason why the drafters of the Constitution made a proviso to save the existing laws before the effective date was to make sure that, Your Honor, that granted the circumstances that Parliament is not able to address all laws supposed to bring it to conformity, that the application of such a section may not result into violation of a provision under the Constitution. That is the reason why we have the the clause saving the existing laws before the effective date, and hence the enactment of Section 7. Having said that, Your Honor, Section 3 tells you that you must address yourself to Article 10 of the Constitution. And what are you addressing yourself to Article 10? Article 10, subsection, clause 1, provides that Article 10 binds all state organs or even persons whenever any of them is either implementing the law, legislating the law, or formulating any policy. In this case, Your Honor, you are implementing the law. And therefore, you are bound by the provisions of Article 10, which lays down the national values and principles of governance. Among those values, Your Honor, is the value of human rights. That human rights binds you. And that is why Section 8 of the Magistrates Court Act, in cognizance of the fact that you are bound by Article 10, has deliberately given you that jurisdiction. Because it is not possible, therefore, for the Constitution to say that Article 10 binds you holistically without any possibility of waiver, and then you are told that you cannot determine a threat, you cannot determine a denial, you cannot determine a violation. Having said that, Your Honor, Article 10 also invites you to look at the rule of law. And also the question of social justice and the principle of equality and equity. That is therefore to say, Your Honor, and I want to associate myself with the submissions made by senior counsel, is there equality, equal application of the law, granted the circumstances and the submission that he has made, because I consider them to be legal arguments. Number 2, Your Honor, the application of Article 10 invites you to look at the question of discrimination under Article 27. Because Article 27 falls within Article 10, where you are mandated or commanded by the Constitution to observe human rights. And therefore to say that, Your Honor, when you retire to make our application to the objection of taking plea, this plea does not conform to the dictates of the new Constitution. That is one ground of the objection. That it is not possible for you to ask Honorable Jayne Kihara to make a plea that will be unconstitutional for failure to conform to the dictates of Section 7. That's one link of our argument. The other link of our argument is that the same does not disclose an offense. Those are two grounds. That if she was to make, or she was to plead to this offense, one, she does not even understand what offense is actually facing her. Because even if we were to make an assumption for purpose of argument that Section 94, subsection 1, that it was in conformity with the Constitution, is it just the proviso that the Jayne Kihara, Honorable, offensive conduct offensive conduct conducive to breach of peace? This proviso of the law must be backed by particulars that speaks to that offense. We therefore submit that the particulars pleaded herein do not speak to the purported or to the alleged offense. These particulars falls within the provisions of Article 33 of the Constitution, the freedom of expression. To admit this charge, therefore, Your Honor, this court would be rising up to the occasion of limiting her rights. And the limitation of these rights, Your Honor, under Article 24, the court has created a test that it must be justifiable for you to limit. It must be justifiable in a free, open, democratic, and civilized society. If that then would be the test and granted her status of members of parliament, would the taking of this plea not amount to the limitation of that particular right? And would that right be a justifiable one in a democratic society? A free society such as this one? A civilized society such as this one? That was not the intention of the legislation. That was not the intention of the enactment of the 2010 Constitution. And then even if she were to plead, Your Honor, even if she was to plead, that she made these remarks, Your Honor, would it this conform to the provision of Article 50, Clause 2, Paragraph 4? And that's the doctrine I love speaking about, the doctrine of Nurum Crimen Sine Lege, that you shall not be charged of an offense if the offense itself was not known in law. And the argument that the offense is not in law is due to the fact of the jurisprudence that has emerged following the enactment of the new Constitution vis-a-vis Section 7 of the 6th Schedule. That had it been to be brought to the conformity to that provision, this offense would not be existing in our books of law. If we had a proactive parliament, and not a parliament like the one that we currently have, this perhaps would have ceased being good law in our books. But granted the circumstances that Parliament itself has not amended this provision, that Parliament is too lazy to bring it into conformity with the provisions of Section 7, are we left helpless? Is it therefore that the DPP has the liberty to charge any other person just because Parliament has become negligent? Parliament has refused to legislate? You are called upon by Section 8 to rise up to the occasion in the event there is ineptness on one part of state organs. And besides that, I may invite my learned friend, Mr. Kihara. Article 10 places you in the same pedestal with the Parliament. Because this court and Parliament is bound up by that provision. So where there is ineptness and negligence on the part of Parliament, the court of law can rise up. In any case, the application of Section 7 vis-a-vis Section 8 of Section 7 to the 6th Schedule, vis-a-vis Section 8 of the Magistrates Court Act, can only be applied by this court, not Parliament. So we invite you, Your Honor, to find that there is no offense that has been disclosed by this particular charge sheet. The same is meant to achieve ulterior motives other than that which is contemplated to protect public interest. It is meant to preserve personal egos. It is meant to preserve at a certain equilibrium for which you do not understand personal emotions. Unfortunately, this is a court of law.